On November 22, 2017, the Caribbean Court of Justice, CCJ, enforced a 2013 London Court of International Arbitration award against the Government of Belize. The sum of the award as of September 7, 2012 was $36,895,509.46 Belize. Fast forward 5 years after, that already huge number ballooned to $91,596,013.22 Belize as of December 15, 2017. More than $54 million of that amount is interest alone. That's because since September 8, 2012, interest has been accruing at 17% compounded monthly. In its application to the CCJ, the Government of Belize sought to reduce the 17% interest to 6%. Its application was successful, and the CCJ found that the applicable post-judgment interest is a statutory rate of 6% simple interest from the date of the certificate compared to the 17% contained in the award. The Honorable Justice Adrian Sanders delivered the judgment.
Judgment interest after an award has been converted to a judgment does not automatically carry the same amount of interest as is contained in the award, and it requires special contractual arrangements between the parties in order to displace the statutory interest rate that is provided for in the Supreme Court Act.
It's a win for the government, and Solicitor General Nigel Hawke sees this ruling as a vindication of government's position.
We were arguing that it should be at the rate of 6% instead of at the rate that was agreed in the award, which was 17% compounded. And the court agreed that since it was now a leave to enforce the award, it should be at the rate of 6%. So our position has been vindicated. Our position has been vindicated that we're saying in terms of the post-judgment interest, it's now at 6% and not 17% compounded.
The 70% compound interest rate is what the arbitrators ordered in 2013. When the CCJ handed down its enforcement order last year, it included the 17%. Both parties were asked to approve the order, but when government's attorneys reviewed the document, it is then that they believe that the rate should have been 6% simple interest. The Belize Bank Limited, through its attorney senior counsel Eamon Courtney, proposed to accept Treasury note rate. That proposal was rejected and the matter was taken before the CCJ. This, according to Courtney, is not a win for the government because his client had proposed a lower interest rate to government before this matter was taken to the CCJ.
It is 17% up until the judgment. After 17%, it is 6%, but it could have been lower, but the government rejected that. One of the things that people should realize is that on the 1st of February, the bank wrote to the Government of Belize offering two things. Firstly, to accept payment over term, over a period of time in installments, and secondly, to accept payment at the rate of Treasury notes that were issued by the government. My information is that the rate that was payable on those Treasury notes was about 3.75 to 5.75. So the offer that we had made was at a less interest rate than the court is now enforcing. So once again, I believe the Belizean people are paying a higher interest rate, 6%, than the bank was prepared to accept.
In court this morning, Courtney sought clarification on whether the date on the order and the certificate is to be amended. Justice Sanders explained that a new certificate needs to be issued with a 6%. However, it will be retroactive to when the original certificate was issued. Reporting for Love News, Hipolito Novelo.